Hello, everyone. My name is Sam Hurwitz, and I am the Associate Managing Editor of the South Carolina Law Review. It is my distinct honor to introduce our next keynote speaker, Judge Richard Gergel. Judge Gergel was born and raised here in Columbia, South Carolina. He attended A.C. Flora High School for 1 year before attending WGA Keenan High School when it went through desegregation. As a junior, he served as the first ever student body president and helped to unite people from diverse backgrounds during the emotional charged time. He also served as the head of a statewide group of student body presidents supporting school desegregation. Judge Gergel then moved north to Durham, North Carolina, and attended Duke University for both undergrad and law school. While in law school, he was a member of the editorial board of the Duke Law Review. After law school, his plan was always to return to Columbia, and he did. After being an associate for a couple years, Judge Gergel opened up his own practice, a plaintiff law firm that specialized in complex civil litigation. He practiced law in his hometown for 30 years before being nominated to the federal bench. In 2009, President Barack Obama nominated Judge Gergel to a seat on the United States District Court for the District of South Carolina. He was later confirmed by the Senate in 2010. In addition to his reputation as a jurist, Judge Gergel is known as a historian and has authored books on South Carolina history and civil rights, including Unexampled Courage, The Blinding of Sergeant Isaac Woodard, and The Awakening of President Harry S. Truman and Judge J. Waties Waring. In addition to Judge Gergel was instrumental in the decision to rename the federal courthouse in Charleston after Judge J. Waring Waring, the courthouse where he resides, and the man about whom he will speak. Ladies and gentlemen, please welcome Judge Richard Gergel.
Well, good afternoon, folks. It's always a challenge to do the first discussion after lunch. The only thing worse is to do the last one of the day. I don't know who has that honor. Folks, I first want to commend the South Carolina Law Review for its timely selection of judicial independence as the subject for this year's annual symposium. It's for certainly a timely subject. Throughout the history of our state, we have had situations where the popular issue of the day clash with the rule of law. In these situations, judges have been called upon to perform the difficult task of upholding the rule of law in the face of great public hostility. The subject of my talk today, United States District Judge J. Waties Waring, is today much admired for his courageous decisions upholding the constitutional rights of minorities to equal protection of the law and access to the ballot, despite harsh public criticism and regular death threats while he served on the bench. Before I focus on Judge Waring, I think it's important to note that in South Carolina's past, there were other courageous judges who have stepped forward in difficult times and issued decisions in the most challenging of circumstances. Let me just give you a few very brief examples. In 1822, the state was rocked by the report of a planned slave uprising in Charleston, led by a free person of color, Denmark Vesey. Rather than try the alleged conspirators in the state's criminal courts in open proceedings, the city of Charleston created a special court of city leaders, no jury, to try the defendants in secret, not allowing the defendants to be present when their accusers testified. 30 men were ultimately executed in these proceedings. These Star Chamber proceedings were denounced by Charleston native and United States Supreme Court Justice William Johnson, who stated at the time, quote, "I have lived to see what I really never believed was possible I should see. Courts held with closed doors and men dying by the scores who have never seen the faces nor heard the voices of their accusers." In the midst of the public hysteria over the Vesey slave conspiracy, the South Carolina General Assembly adopted the Negro Seamen's Act, requiring every black sailor who came into the Charleston harbor to be jailed until the ship left port. Justice Johnson sitting as a circuit court. They didn't have district courts at the time. Supreme Court justices rode circuit. So Justice Johnson sitting as a circuit judge declared the Negro Seamen's Act unconstitutional as a violation of the Supremacy Clause in the case of Ellison versus Dessau. He observed that the state act in violation of the United States Treaty with England was, quote, in effect, a repeal of the laws of the United States, converting a right into a crime. Justice Johnson was widely condemned in South Carolina for his actions, and he ultimately had to relocate to Philadelphia because of his ostracism in his native city. A few years later, South Carolina went through something related to the nullification crisis. South Carolina leaders declared the right to void any federal law to which they disagreed. In the midst of this dispute, the General Assembly adopted a law requiring all members of the state militia to take an oath to the state of South Carolina rather than to the United States. A member of the state militia, Edward McCready, was denied a commission because he refused to take the state oath. The matter became before the South Carolina Court of Appeals in the case of McCready versus Hunt, that the state, which held that the state oath was in violation of the Supremacy Clause and was thus unconstitutional. The Chief Judge of the Court of Appeals, John Belton O'Neill, wrote the order and recognized that the court's decision would be very unpopular. He observed, quote, at a time like the present, when waves of popular fury are continually breaking upon the walls of the Temple of Justice, it is critical that the courts perform their duties independently and fearlessly. Now, after that decision, what happened? The Court of Appeals was abolished for 30 or 40 years. So some people don't exactly believe in judicial independence as much as those perhaps in the room here today. When Judge Waring confronted great public hostility in the performance of his judicial duties, he knew about these other judges, and they inspired him, and he felt great strength from their prior examples. It is therefore very timely and important to recognize and honor those judges who have upheld the principles of judicial independence in difficult times. With that, let me turn to the story of unexampled courage. On December 9, 1952, at 3:15 p.m., Thurgood Marshall, the legendary chief counsel of the NAACP, stepped to the podium of the United States Supreme Court chamber and commenced his argument that the Supreme Court's long-standing precedent in Plessy v. Ferguson should be overturned. He was followed by John W. Davis, himself a living legend, as one of the greatest oral advocates of his day, who argued that Plessy remained good law. These two titans of the bar met at the crossroads of history, with the outcome of this historic case to define what type of nation America would be. The stakes were huge. When major portions of America remain a rigidly segregated society in which many of its African American citizens lived in a twilight world between slavery and freedom, or would this country finally live up to its promise of equal justice guaranteed by the American Constitution? Many would assume that the case for this momentous argument between Thurgood Marshall and John W. Davis was Brown versus Board of Education. That assumption would be wrong. The case argued that day and continued into the next day was Briggs versus Elliott, which involved a challenge to the racially segregated public school system in Clarendon County, South Carolina. The Briggs case would later be consolidated with 3 other school desegregation cases under the name Brown versus Board of Education. Thurgood Marshall elected to argue the Briggs case exclusively in the first round of arguments in 1952, believing it was the most important of the school desegregation cases pending on the Supreme Court's docket. The first case that was filed, the first case where the groundbreaking evidence of Dr. Kenneth Clark's doll studies was offered, and the only case in which a dissent had been filed asserting that Plessy should be overturned. That dissent by United States District Judge J. Waties Waring of Charleston concluded that all government-mandated public school segregation violated the Equal Protection Clause of the 14th Amendment and was thus, in his words, per se unconstitutional. When the Supreme Court issued its unanimous decision in Brown on May 17, 1954, Waring's per se standard was the centerpiece of what is now regarded as the most important case in American history. It is thus altogether fitting that on the 75th anniversary year of Judge Waring's historic dissent, that we pause to remember his remarkable opinion that helped this country untie the Gordian knot of Jim Crow. It should be noted, however, that the forces which propelled the public school segregation issue onto the docket of the United States Supreme Court did not simply begin with the filing of the Briggs suit or the citizens petition, which made the simple request that black children of the Clarendon School District have access to a school bus just like the white children. It was instead a now long forgotten incident of racial violence inflicted on a returning African American World War II veteran that would set off a cascading series of events, ultimately leading to that eventful day in December 1952 when Thurgood Marshall stepped to the podium to argue Plessy v. Ferguson was no longer good law. As World War II came to an end, 900,000 African Americans, most of whom were from the rural South, were discharged and returned home to their communities. While African American soldiers served in segregated units during World War II, the military had afforded opportunities for training and advancement. Further, having served their country and defended American liberty and freedom abroad, returning African American veterans expected more respectful treatment once they returned home. Instead, the old practices of disenfranchisement and Jim Crow segregation persisted, and returning veterans who resisted acquiescence to these customs were often viewed as a threat to the racial status quo. The returning African Americans wanted their own New Deal. Late in the afternoon of February 12, 1946, Sergeant Isaac Woodard, a battlefield-decorated soldier, boarded a Greyhound bus in Augusta, Georgia. After discharge earlier that day from nearby Camp Gordon, and he was traveling to Columbia and then on to his hometown of Winnsboro, where he was to rendezvous with his wife after 3 years of separation occasioned by his war service. Sergeant Woodard struck an impressive figure in his dress uniform, with sergeant stripes on his shoulders and battlefield decorations on his chest. During one of the frequent stops on the bus along the way, Sergeant Woodard approached the white bus driver and asked at the next stop could he step off to relieve himself. At that time, interstate buses did not have restrooms, and Greyhound bus drivers were instructed to accommodate such requests from their passengers. Instead, the bus driver snapped at Woodard, "I ain't got time to wait," and ordered him to return to his seat at the back of the bus. To the apparent astonishment of the bus driver, Sergeant Woodard spoke back, telling him, "Talk to me like I'm a man. I am a man just like you." The stunned bus driver told Woodard to go ahead, but in the following stop, in Batesburg, South Carolina, the bus driver, now apparently no longer concerned with staying on schedule, departed his bus in search of a police officer to have Woodard removed from the bus and arrested. Woodard soon found himself confronted by the police chief of Batesburg, Linwood Shull, who responded to Woodard's effort to explain himself by striking him over the head with his blackjack and escorting Woodard off to the town jail under arrest. On the way to the jail, Woodard was repeatedly beaten with Shull's blackjack, ultimately driving the end of the baton into both of Woodard's eyes. The sergeant was then thrown in a semi-conscious state into a jail cell for the night. When he awoke the next morning, he realized he could not see. Later that day, Woodard was transported to the Veterans Hospital here in Columbia, where he was determined to be irreversibly blinded. Accounts of the Woodard beating and blinding were reported in the black press and received nationwide attention when Orson Welles focused on the incident in his weekly national radio program on ABC Radio. Mass meetings were organized in black communities across the nation to protest Woodard's treatment. Meanwhile, other black veterans returning to the homes in the rural South confronted other incidents of racial violence, including racially inspired murders. No state prosecuted those involved in any of these incidents. On September 19, 1946, a delegation of civil rights leaders met with President Truman in the Oval Office, deeply distressed by the wave of racial violence against black veterans. Prior to the meeting, Truman's staff advised him that despite his desire to respond to the concerns of civil rights leaders, there was little he could do as a practical matter as president to address these incidents. As the meeting opened, civil rights leaders urged Truman to call Congress back into session to address the spreading violence against black veterans. The president expressed sympathy, but lamented there was simply not the support in Congress or in the public for new civil rights legislation. Leading the group was Walter White, and in this image, he would be to our right of President Truman. Now, Walter White is sort of a forgotten figure in modern civil rights history, but in 1946, he was the executive director of the NAACP, was the most important civil rights leader in America, and was a strong political ally of Truman. It was apparent to Walter White that the president did not appreciate the gravity of the situation. Mr. White changed the discussion by sharing with the president in detail the blinding of Sergeant Isaac Woodard. As the tragic story unfolded, Truman sat riveted and became visibly agitated by the idea that a uniformed and decorated American soldier had been so cruelly treated. Abandoning the advice of his staff, Truman stated, "My God, I had no idea it was as terrible as that. We have got to do something." The following day, Truman wrote his Attorney General, Tom Clark, and shared with him the story of the blinding of Isaac Woodard, noting that the police officer had deliberately put out Woodard's eyes. Truman made it clear that the time for federal action had now arrived. 3 business days after President Truman's letter arrived at the Department of Justice, the Attorney General personally made the unprecedented announcement that the Department of Justice would prosecute Batesburg Police Chief Linwood Shull for the deprivation of the civil rights of Isaac Woodard. During this era, a federal prosecution of a white police officer for violating the civil rights of a black citizen in the Deep South faced daunting challenges. Jury rosters were drawn from voter lists, and African Americans were almost entirely disenfranchised. All white juries and grand juries were generally hostile to any civil rights claims, and local prosecutors wanted nothing to do with civil rights cases. Indeed, a decision was made by the Department of Justice to charge the police chief with a misdemeanor because it doubted a South Carolina federal grand jury would return an indictment. The announcement of the prosecution of a police chief brought an outcry from local elected officials who attacked what they viewed as federal meddling in a purely local matter. The United States District Judge J. Waties Waring was assigned the case. Judge Waring was an 8th-generation Charlestonian, and his father was a Civil War veteran. Judge Waring was himself initially skeptical of the federal prosecution, but when the blinded sergeant took the stand and detailed his vicious beating at the hands of Chief Shull, Judge Waring knew a grave wrong had been done. He was also equally aware that his all-white jury would not convict the obviously culpable officer. He was right. 28 minutes after the deliberations commenced, the jury announced the acquittal of Linwood Shull. As Shull's supporters cheered his acquittal, few noticed that Judge Waring's wife, Elizabeth, who had attended the trial, left the back of the courtroom in tears. Judge Waring joined his wife later that evening, and both were traumatized by the trial over which he had just presided. The Shull trial forced the judge and his wife to stare directly into the Southern racial abyss, a view which would forever transform both of them. Judge Waring described the Shull trial as his personal baptism of fire and his Michigan-born wife's baptism in racial prejudice. The Warings returned home after the Shull trial, resolved to learn more about the issues of race and justice, which they had previously given little thought. These were not subjects in which polite society and white Charleston could have a discussion. The Warings decided to undertake their own self-directed study. Each evening after dinner, Elizabeth would read out loud a portion of a selected work to allow the judge to rest his eyes after a day of handling his judicial duties. The couple would then discuss what they had read, often while driving around Charleston in the evening, a favorite pastime. Among the books they read was a cutting-edge work, The American Dilemma by Gunnar Myrdal, a brilliant 1,400-page study of race in America funded by the Carnegie Foundation, which would later be cited in the Brown decision, and Myrdal would later be awarded the Nobel Prize. Once the Warings had read all 1,400 pages together, there was no turning back. As Judge Waring's new views on race and justice evolved, George Elmore, a black businessman in Columbia, filed suit in federal district court in 1947, challenging the South Carolina Democratic Party's all-white primary. Elmore was represented by Thurgood Marshall, then 39 years of age, who was already developing a reputation of almost legendary proportions as a skilled litigator and legal strategist. South Carolina political leaders were united in their determination to preserve the white primary, notwithstanding clear U.S. Supreme Court precedent, Smith versus Allwright, holding such white primaries unconstitutional. Judge Waring fully understood that any decision recognizing the right of minority citizens to vote would produce an intensely hostile and possibly violent public reaction. But Waring concluded, as he later shared with an historian after he retired, that his choice was either, quote, to be entirely governed by the doctrine of white supremacy or to be a federal judge and decide the law. On July 12, 1947, Judge Waring issued his decision in Elmore v. Rice, declaring South Carolina's white primary unconstitutional. He ended his order by stating, "It is time for South Carolina to rejoin the Union and to adopt the American way of conducting elections." The groundbreaking nature of the Elmore decision was immediately appreciated by the leadership of the NAACP. In a private note to Thurgood Marshall, William Hastie, who would later be the first black federal judge appointed in American history, stated, "Thurgood, I have read the South Carolina opinion 3 times, and I still don't believe it. In many respects, I think it is your greatest legal achievement." A copy of Judge Waring's order was hand-delivered the day afterwards to President Truman. But the segregationists would not give up. Soon a new party rule was adopted, allowing blacks to vote in the party primary so long as they pledged to support racial segregation. Surprise, a new lawsuit was filed by Thurgood Marshall. And on July 16, 1948, Judge Waring summoned all 93 members of the Democratic Party's executive committee to his courtroom in Charleston for an emergency hearing. Waring denounced their efforts to defy his earlier ruling and explained that a federal judge faced with contempt could impose a fine or a jail sentence. He wanted those present to know that if there were any future violations of his order, there would be no fines. There he was preparing to incarcerate the most powerful white political leaders in the state to support the rights of African Americans to vote. Thereafter, African Americans by the thousands registered to vote in South Carolina. And the gentleman on this image on the second to the left is Mr. Elmore being sworn in to vote. The response of South Carolina white supremacists was thunderous. Death threats, written and oral, were constant. A cross was burned at the Waring's home on Meeting Street, and bricks were thrown through their living room window. On the order of the Attorney General, Judge Waring was provided 24-hour U.S. Marshal security. Time magazine described Judge Waring as the man they loved to hate, but also noted he was proving to be a person of cool courage. If the purpose of the unprecedented vilification of Waring was intended to cower him, it didn't work. Instead, he continued his study and reflection on race and justice in America and became convinced that the foundation of Jim Crow segregation, the Supreme Court's 1896 decision in Plessy v. Ferguson, was legally, historically, and morally wrong. After the Supreme Court ruled with plaintiffs 9-0 in civil rights cases issued in June 1950 involving a separate but not equal Texas law school, Sweat v. Painter, and a graduate program where an African-American student was required to sit in the hall outside the classroom. That was McLaurin versus Oklahoma Board of Regents. Judge Waring became convinced that the Supreme Court was ready to reverse Plessy if a proper school desegregation case was on the docket. There is some evidence to suggest that Judge Waring actually knew the outcome, that while he was being vilified in South Carolina, he was greatly admired in the federal judiciary and had been at the U.S. Supreme Court prior to his decisions here. And some had thought he had already counted noses. Waring noted on his trial docket a case from Clarendon County, South Carolina, Briggs v. Elliott, which sought to equalize the facilities in the district's black and white schools. At the time, the NAACP had a very tough slog through the federal courts in the South, but had come upon a strategy that worked. They would not challenge the separate portion of the Plessy decision. They would challenge only inequality, because the practice was not separate but equal, but separate and unequal. This was a highly successful legal strategy. They were winning cases, but the strategy was controversial because every time the NAACP would use Plessy v. Ferguson to support a case, it would cement a little bit further the inferior legal rights of African Americans. The original Briggs complaint did not explicitly allege that segregated schools were unconstitutional. That was not an accident. They were not ready then to challenge frontally segregation. When the plaintiff's attorney, Thurgood Marshall, appeared at the Charleston courthouse on November 17, 1950, that's, by the way, is Marshall arriving to try Briggs versus Elliott, he was attending a pretrial conference. And when he arrived at the federal courthouse, he was advised by the marshal, the judge wants to see you in chambers. He was ushered into the judge's office, and to his apparent surprise, no opposing counsel. Ex parte alert, folks. Judge Waring told Marshall, I don't want to try another separate but equal case. Bring me a frontal attack on segregation. Marshall responded, Judge, it's on our agenda, it's just not tonight. We don't think this is the case. We don't think this is the time. What he was saying was they'll kill my plaintiffs in Somerton if they challenge segregation. Judge Waring was unpersuaded, telling Marshall, this is the case. This is the time. Marshall urged the judge to think practically, noting that any decision by him overturning Plessy would be reversed on appeal by the Fourth Circuit. Judge Waring explained that since the challenge to public school segregation contested the constitutionality of a state law, under then practice, the case would go from a three-judge panel directly onto the docket of the United States Supreme Court, no certiorari. Up to this point, the NAACP's highly successful strategy had been to carefully build one case on top of another, never trying to get ahead of the Supreme Court. The path Waring was suggesting was a bold and unflinching attack on segregation, root and branch. A few minutes after this dramatic encounter, Judge Waring convened the pretrial conference in Briggs. and publicly pressed Marshall on whether he was challenging the constitutionality of public school segregation. Marshall stated that he was, and agreed to dismiss his pending lawsuit and refile a new Briggs complaint as the first frontal attack on public school segregation in American history. The newly filed Briggs case was tried in the Charleston Federal Courthouse in May 1951 before a 3-judge panel which included Judge Waring. In prior years, civil rights cases in the South were sparsely attended by members of the black community, lest they be identified as members of the NAACP. That would, if you were a school teacher, that would get you fired, or as challengers to the racial status quo. But on the morning of May 28, 1951, as the sun rose in Charleston, African Americans lined up at the federal courthouse and down Broad Street as far as the eye could see, hoping to observe what many thought might be the most important case in American history. As Thurgood Marshall entered the federal courthouse that morning, he turned to his young assistant, Bob Carter, and told him, "It's all over, Bob." Carter was confused. He said, "What do you mean?" He says, "They're not scared anymore." Those in attendance in the courtroom were not disappointed by the performance of Thurgood Marshall and his trial team. The trial included the testimony of Dr. Kenneth Clark, a social psychologist who had done groundbreaking research on the effects of segregation on black children using black and white dolls. The crowd was also entertained by Marshall's devastating cross-examination of the state's key witness, whose last name, ironically, was Crow. You can't make it up. As Judge Waring anticipated, the majority of the panel ruled that South Carolina's laws mandating segregated schools were lawful under the Plessy Doctrine. But Judge Waring, fully aware he was writing a dissent for the ages, wrote an elegant and brilliant attack on the foundations of segregation in America. He stated, quote, "We must face without evasion or equivocation the question as to whether segregation in education in our schools is legal under the 14th Amendment." Judge Waring discussed in detail the testimony of Dr. Clark regarding the doll studies, which he stated demonstrated that the humiliation and disgrace of being set aside and segregated as unfit to associate with others of different color had a damaging effect upon the mental processes of our young. After carefully examining the language of the 14th Amendment and the recent decisions of the United States Supreme Court striking down segregated schools of higher education, Judge Waring concluded, segregation in education can never produce equality, and it is an evil that must be eradicated. Segregation in education adopted and practiced in the state of South Carolina must go and go now. Segregation is per se inequality. Judge Waring also noted in his dissent the targeted retaliation of the Briggs plaintiffs, the targeted retaliation they had experienced as a result of their participation in the case, which included the loss of jobs, the calling in of farm loans, and the failure of the local volunteer fire department to respond to a fire that burned down the home of the plaintiff's community leader, Reverend Joseph Delane. Judge Waring stated that the plaintiffs had, quote, shown unexampled courage in bringing and presenting this cause in the face of the long-established and age-old way of life which the state of South Carolina has adopted in practice and lived in since and as a result of the institution of human slavery. Judge Waring's dissent, issued in June 1951, was the first challenge to government-mandated segregation by a federal judge since Justice Harlan's historic dissent in Plessy v. Ferguson 55 years earlier. In early 1952, some 6 months after the Briggs v. Elliott dissent, Judge Waring announced his retirement and, exhausted with the ostracism within Charleston, moved to New York City. Waring followed closely later school desegregation cases filed in Virginia, Delaware, and Kansas, all which were consolidated before the United States Supreme Court under the name Brown versus Board of Education. And all the other school desegregation cases involving 14 different judges, only Waties Waring concluded that public school segregation, even if the facilities were equal, violated the 14th Amendment. On May 17, 1954, the Supreme Court handed down unanimously its landmark decision in Brown versus Board of Education. You will notice the first name there is Oliver Brown versus the Board of Education in Topeka, and the second one, Briggs v. Elliott. The Supreme Court found that public school segregation, quote, generates a feeling of inferiority, end quote, in children, and may affect their hearts and minds in a way unlikely ever to be undone, citing the Dahl studies of Dr. Clark. The court explicitly cast aside the separate but equal doctrine and adopted the per se rule that all government-mandated segregation was unconstitutional, first advanced by Waring in his Briggs dissent. On the night of the Brown decision, the leadership of the NAACP traveled to Judge Waring's small Upper East Side apartment to toast the man they viewed as the father of Brown. Judge Waring met with Chief Justice Warren shortly after the Brown decision to express his admiration for the court's clear-cut decision and told the Chief Justice, "I've been pretty lonely up to this point, and I was greatly relieved by the court's Clarendon school case." The Chief Justice responded that Waring was the one to be admired because you, Waties, had to do it the hard way. Judge Waring was always philosophical about what he called the unpleasant repercussions of his civil rights decisions. In an oral history late in life, Judge Waring observed, "Taking the whole thing in balance, I think I am enormously fortunate because you don't often in life have the opportunity to do something that you really think is good. I think a great stroke of fortune came down my alley. The other penalties don't amount to anything. They're offset by what I think is a really important contribution to the history of our country." Thank you very much.